Ms. Melito, how many businesses does your organization represent?
We represent 350,000.
And what's the size? Is there an average size to those businesses?
Yeah, we say our average size of member business is around 10 employees or less.
Around 10. There's no small business exemption here, so I mean, a 10-employee business can be organized by a union, right?
Yes, absolutely. And I would point to the board's own statistics, too, that show, the average bargaining unit size as of 2013 was about 24 employees. So I think units have gotten smaller over the last 10
So you said 350,000?
350,000.
350,000. So I'm just trying to imagine this. 350,000 small businesses around the country, average size 10. I mean, the picture I get is that they're all sitting around every day at breakfast with their labor lawyer, just poised, waiting to be able to respond to an election, when the truth is probably that's the furthest thing from their mind, right?
They don't have an attorney. Most of the members with whom I speak do not have an attorney. They maybe consulted somebody to draw up their articles of incorporation, but they don't have an attorney.
How many of them do you suppose in a business of 4, 5, 6, 10, 12 regularly consult their fax machine?
Very rarely, unless they're looking for a timeshare or a business loan.
So the notice the notice arrives, the notice of an election arrives on day one, and then a whole series of things begin to happen. I mean, first you have to go find you or Mr. Carter or some lawyer to advise you about it. If you don't find someone, and you're an employee and you make some mistake, I mean, you make a statement to an employee that's not strictly according to the to the rules, what happens? What's the penalty for that?
The consequences are very severe, as we've heard from the experienced labor practitioners here. I mean, they have to get it right. This hearing notice comes out, it's faxed in on a Friday. They don't check their fax machine until maybe Monday. I mean, I just want to back up there, too, and go back to the fax machine, too. I think this is legal ramifications, to your point about the seriousness of it. And I think for the business owners I talk with, too, anything legal related, like a complaint or a civil procedure, they expect it to come in the mail, not through the fax. So, they're just not going to be checking the fax and then not know what to do with this.
Mr. Carter, an employer who's who's about to be organized needs counsel, right?
An employer who doesn't have counsel is at severe jeopardy.
And what's the cost of all that?
Well, the cost of all that can be tens of thousands of dollars.
Yeah, even for an 8 or 10 or 12 or 14 person unit?
Absolutely. It's a matter of the hours spent by the attorney in preparing the materials. The cost will go up, Senator, because the amount of work that needs to be done under these regulations, under the new regulation, exceeds the amount of preparation that is currently anticipated.
But under the rule, under day one, you get a fax copy saying you've got an election petition filed, and on day 2 or 3, you've got to publicly post an election notice, and you've got to do that correctly, right? I mean,
if you don't do it correctly and the employees themselves decide not to vote the union in, the union can petition for another election and put the employer through that same expense again.
You've really got 1 day to get legal advice before you post that notice, or you might do it wrong. Is that right?
Absolutely correct.
What's the reason for this? I mean, the median for an election is 38 days. I mean, this reminds me of Western movies about frontier justice and hanging judges. I mean, if you can do it in 8 days, why don't we just say do it in 2 days or 12 hours or 6 hours? And I mean, if the median is 38 days and 56 days is the most for almost all elections, a little over a month would seem to me to be a fair amount of time for both sides to make their point. And even under the rule, am I correct that if you get to the 11th day, the union has a right to postpone the election, but the employer doesn't under the rule? Is that correct?
It's even before that. The union can waive the time necessary after getting the Excelsior list, the list of employees, and that way they can make the election happen more rapidly. And what is the reason for this? The NLRB has stated that it's because we want to cut out unnecessary delay. The United States Chamber of Commerce doesn't believe that due process is unnecessary. And the Senate has confronted this issue in the past and has concluded, as Senator Kennedy stated in 1959, 30 days is necessary to ensure that we don't rush these people into making this decision. It's an employee right that's at stake, Senator.
Thank you. Senator Murray.